Test 1, 2, 3. 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 Okay. One, 2, 3. Test 1, 2, 3. Test 1, 2, 3. Test 1, 2, 3.
Welcome to today's presentation. My name is Alice Hogue and I'll be your instructor. Today we're talking about oil and gas lease basics. And the oil and gas lease is really the cornerstone exploration agreement in the oil and gas business. Now, when we're talking about an oil and gas lease, if you've ever seen one of these, they are usually on legal size paper. They're double-sided and they're about 8 points. It's usually an 8-point font, something like that. So very, very tiny print. So that is my setup for my Cajun joke today. And as you know, the two main characters in any Cajun joke are Boudreaux and Thibodeau. And if you have to add a third one in, you throw in Pierre. So I guess y'all want this with the accent. Boudreaux and Thibodeau, they decided they wanted to start a dairy farm in Opelousas, Louisiana. And they heard they had something there in Houston, Texas called the rodeo. And at the rodeo, they heard they bought some livestock and you could buy a bull cow there, and that's what they needed for their dairy farm. So Boudreaux says, Thibodeau, I want you to go over there with Pierre, and I want y'all to go to Houston, And he says, I want you to buy the best bull cow that money can buy. And then once you get it, I want you to go to Western Union, send me a telegram, and tell me to bring the truck. So man, Thibodeau thought that was a great idea. He had never been to the big city of Houston. So he goes to Houston and he buys the best bull cow that money can buy at the rodeo. He's all impressed with himself. So he decides it's time to send Boudreaux a telegram to tell him to come bring the truck. So he goes into the Western Union store. He says, Mr. Western Union man, how you doing today? The Western Union man said, well, I'm doing fine. He said, well, I need to send a telegram to my friend Boudreaux. You see, we bought this dairy cow or this bull cow for our dairy farm, and I need to get it back to him. So I need to tell him to bring the truck. So the Western Union man said, well, okay, that's great. So Thibodeau reaches into his pocket and he pulls out 1 quarter. He doesn't realize he only got 1 quarter left. He done spent all his money on the hotel and the restaurants and the dancing and the drinking and the partying. So he says, Mr. Western Union man, how much word I can buy with this here quarter? And so the Western Union said, oh, Mr. Thibodeau, I'm sorry to tell you, but you can only buy 1 word with that quarter. He said, man, 1 word, how am I going to tell my friend Boudreaux to bring the truck with just 1 word? So he taught and he taught and he taught and he said, aye, the word is comfortable. And the Western Union man looked at him and said, comfortable? How that's going to tell your friend Boudreaux to bring that truck? And Thibodeau said, Misha, don't you worry about that, no. My Boudreaux, he read real slow him. He'll look at that word and say, comfortable. Well, I'm so glad y'all like that. Now, that is really one of my favorite jokes to tell for the oil and gas lease basics class, because just like Boudreaux read everything real slow, same thing for the oil and gas lease. We have to read every word of that oil and gas lease, word for word, line by line. And that's what we intend to do in this class today. So let's begin with, first of all, an agenda for the oil and gas lease. Here is our agenda. So we want to start with an introduction. And in the introduction, I just want to go over a basic definition with you. I want to give you a little bit of a history lesson, and I want to go over the mutual benefits. In other words, why a lessor would want to enter into an oil and gas contract and why a lessee would want to enter into it. And then we'll talk about the different kind of standard forms you've heard out there. One is a producer's 88, which I know that most of you are familiar with, but there's also attorney's forms and landowner forms. And then from there, we are going to go into each and every lease provision. Now, you should have, along with your PowerPoint slides, an oil and gas annotated lease. That is a lease that looks like it's on double-sided legal size paper, and it's got 8-point font, and it's actually a lease that I made up. But along the left side of it, you have in red the name of every provision in that lease. So that if someone says, well, what's the savings clause in that provision or in that lease, you will then kind of have a little go by, a little cheat sheet, if you will. So that is the lease provisions that we're going to go through. And the lease analysis part of it is also the same thing that you will be able to use that go by and analyze leases in the future. Now, the next thing we're going to talk about is this definition of an oil and gas lease. Is and its essence. It is a contract. It is an agreement between the parties, and the agreement is between the lessor and the lessee. Now, one easy way to remember that is that because you're going to hear the term lessor, lessee, lessor, lessee, lessor bandied about. So the way I remember it is that lessee sort of rhymes with company, and lessor rhymes with landowner. So the agreement is that a lessee, that's the oil and gas company, has permission to enter onto the land because that the landowner or the lessor has signed an oil and gas lease. That gives the company the right to enter the property. And what do they get in return? Well, they get a royalty payment and they get something called a bonus payment. Now, bonus payment is a payment that's made up front, and it's usually so much money per acre. So in some places in Oklahoma, it would be like $300 an acre. Or it could be anything from like $2,000 or $25,000 an acre. So it's a payment that we make to the landowner to get them to sign that oil and gas lease. And usually the bonus payment itself is a lot of money. But really, where the real money is made is with this royalty payment. The royalty payment is a percentage of the actual production. And so these rates are negotiated, and we'll talk about that when we get to the royalty provision. Now, because an oil and gas, while it's in the ground, is considered real property, as a result, if we want to stake our claim or protect our claim, that oil and gas lease has to be recorded in the county records. So now let's look at the mutual benefits. Why would an oil and gas company want to enter into an oil and gas lease, and why would a landowner want to enter into one? And the bottom line is it is for money. Look, none of us would be in this business if it weren't for the substantial profits that oil and gas companies make when they drill for oil. So the oil and gas company is getting the profits, clearly, but they're also getting the right to enter onto the property. The right to enter onto the property. Now, the lessor, as we said, gets a royalty payment, and they get other payments like the bonus payment. That's what we use up front. We say, if you sign this lease, we'll give you this draft check that has this huge dollar number on it. To a lesser extent, they also get paid delay rentals, and they also get paid what we call shut-in rentals. Payments. So let me just give you a little bit of history. I always have to give y'all a history lesson every chance I get. So you will recall that the first oil and gas lease was drilled in the United States in Titusville, Pennsylvania, by a man named Colonel Edwin L. Drake. Now, he is known as the founder of the modern petroleum industry. Now, one of the reasons they started drilling for oil back then was because people that had saltwater wells were complaining that an oily substance was coming up out of the ground. So what is a saltwater well? What are you drilling for in a saltwater well? And the answer is that you're drilling for salt. And why is salt important? It's important as a preservative and as a seasoning. So the leases that were in place when Edwin L. Drake struck oil in 1859 were saltwater leases. And so that is really the prototype for the oil and gas leases that we have today. It's based on this old saltwater extraction lease. And so some of the terminology comes from the 1850s. So things that may not make sense to us today made a lot of sense back then. So that's why you'll hear a lot of these unusual terms. So I'm going to give you that as a background. Now, as I said, there's different types of leases out there. One of the most common is the Producers 88. Now, you may not know this, but Producers 88 stands for, well, what happened was there was a group of producers, oil and gas companies, that got together in Oklahoma, and they came up with a standard lease form or a lease form that was favorable to oil and gas companies. And they brought it to a company called Burkhart Printing, which is still in Tulsa, Oklahoma. And they said, can you print these out for us? Now, Burkhart Printing named this form after the client, the producers, and the next sequential number in its printing sequence. So the print before this could have been Hogue Wedding 87. That's the client. That's the print number. This is the client, that's the print number. It means no more than that. So don't be lulled into a false sense of security when you see that producer's 88 at the top of the lease, and then you'd say to yourself, well, I don't even need to read this lease because, it's a standard form. There's no such thing as a standard form oil and gas lease. There's standard provisions, and that's what we're going to go through. There's standard provisions in there. In fact, there was a United States Supreme Court case that said if person A did this, person B would give them a producer's 88 lease. And the court held that that contract was void for vagueness because there is no such thing as a producer's 88 lease. In fact, the form that I gave you, that I created myself, you'll note has at the top of the page, producer's 88 lease. So landowners began to think that these terms were favorable to them, and they would say, we will only sign a producer's 88 lease. So unscrupulous landmen or oil and gas companies would go in and just type producer's 88 at the top of the form. Attorneys got involved. They then started drafting forms for the landowners, for the oil and gas companies. Once again, those leases were titled producer's 88 lease. So it really means absolutely nothing. Now, with that background, while there's no standard lease, there are standard lease provisions. And these are the standard lease provisions that we'll cover today. The granting clause, the Mother Hubbard clause, the Habendum clause. See some of these unusual names here. Habendum clause, the royalty clause, the drilling and delay rental clause, shut-in royalty clause, dry hole, continuous drilling clause, production cessation, pooling and unitization, Pew clause, surrender, force majeure, assignment, warranty, proportionate reduction, and legal effects and signatures. Now, pooling and unitization, I'm just going to go over very briefly, as well as the Pew clause. The Pew clause is really an amendment to the oil and gas lease. And we'll show you how that kicks in week 3 when we talk about the pooling and unitization. But it's a very common amendment, and I want you to understand what it means and how it applies. Next, we'll look at the surrender. Oh, we already went through these. Okay, surrender, force majeure, assignment, warranty, proportionate reduction, legal effects and signatures. All right, so now let's begin with the first clause that's in that lease, and that is called the granting clause. Now, the granting clause is important because it defines the scope of the rights. So, in other words, it reads, this agreement made this blank day of blank between blank lessor, whose address is this, and blank lessee, whose address is this, witnesseth, lessor, in consideration of so much money, hereby grants. So there's your granting language. That's what makes it the granting clause. Hereby grants, leases unto lessee the right to drill for oil and gas in the following lands. And then here's where it'll give your legal description. In this case, all right, title, and interest in the southwest quarter of this section, township, and range. Now, as I said, the granting clause defines the scope of the rights granted. So the first thing it sets is the date, on this blank day of blank. Now, why is the date important in an oil and gas lease? Well, for one thing, every lease has a term in it, what we call a primary term. And the lease expires at midnight on the last day of the primary term. So what is the primary term? It's based on what the date is in this granting clause. The next thing it does is it identifies the party. This is the lessor, this is their address, this is the lessee, and their address. The next important thing that it does is it states consideration. Now, consideration is a legal concept in contract law. And what it basically says is for a contract to be legally binding, both parties have to give up something. So the consideration in an oil and gas lease is the bonus payment. The oil and gas company is giving up the bonus, and the landowner is giving up their right to drill. So that's the consideration. Now, usually when we talk about consideration, we talk about the money. So most people would say that the bonus is the consideration. Now, usually here you'll see $1 or $100, or sometimes you'll see OVC, which stands for other valuable consideration. The actual consideration is the bonus amount. So why don't we put the bonus amount as the consideration? And the reason is because usually there's a lot of competition in these areas, and we don't want other people to know what we're paying for a bonus payment. Also, The courts don't care what the consideration is. All they care about is that there was consideration. So we're establishing here that there was consideration. So that is why we don't use the actual bonus amount. And finally, it's privacy for the landowner. They don't want all their neighbors to see what bonus they negotiated. So in order to protect all those parties, we'll just say something like $1 or $100 or $100 in OVC. The next thing that's important about the granting clause is it talks about the substances covered. Now here this says oil and gas. Every clause in this lease is negotiated. So this could say oil only, this could say gas only, this could say oil, gas, and all other minerals, this could say coal bed methane. Whatever it is, the substances covered are set forth in the granting clause. And finally, it describes the property and the interest. This is very important. So the legal description has to be 100% correct or the lease is void. So here it says all right, title, and interest in the southwest quarter of the section of the southwest quarter of this section, township, and range. Now the next clause goes right after the legal description, and it is something known as the Mother Hubbard clause. So let me show you what that Mother Hubbard clause looks like. It's basically a clause that follows the legal description, and it reads, this lease also covers and includes all land owned or claimed by lessor adjacent or contiguous to the land particularly described above, whether the same be in said surveys or in adjacent surveys, although not included within the boundaries of the land particularly described above. Then it says, for all purposes of this lease, said land is estimated to comprise so many acres, whether it actually comprises more or less. So sometimes you'll hear this clause referred to as the more or less clause. Now, let's talk about what the Mother Hubbard clause is for. And I would also like to give you a little bit of my theory of how it got named this Mother Hubbard clause. Well, as you know, there's a lack of a uniform land system in the United States. Some states have meets and bounds, like Texas and the original 13 colonies, and other states have section, township, and range. So as a result, especially in states like Texas, where we have meets and bounds, literally measurements and boundaries, those measurements and boundaries will say so many feet to the tree, so many feet to the creek, so many feet to the barn, and so many feet to the fence. So over time, what happens? Let's say all these things existed in the 1920s. Now it's 2015. So what happened to that tree? Got struck by lightning. What happened to the creek? It dried up. What happened to the barn? It caught on fire. What happened to the fence? It fell down. So now we're in a position where we don't really know exactly where that tree was. And we don't want to run the risk of us saying, okay, we think the lease was here. We think this is where the tree was and the fence was. And the landowner comes along and said, aha, the tree was actually here. And so you didn't lease this area. Therefore, we're going to drill our own well, and they haven't put any money into it. They haven't done any geology or seismic or anything like that, but they're going to take advantage of all the research that the oil and gas company does and put their own well and basically compete with the oil and gas company. So that's the purpose of this clause, because there's no way for us to be 100% sure where the tree was, where the fence was, where the barn was, and where the creek was. And so we say, look, the intention of the landowner is to lease all the acreage that they have either adjacent or contiguous to this land. So if it's land that's right next to it, even if it's not specifically described, all of that is included in this lease. That's all it means. So the main thing it does is to protect the lessee. Now, every time I would go to a class like the one that you're attending now, or rather an in-person class, I would bravely raise my hand and I would ask, why is it called the Mother Hubbard clause? And I got very different answers over the years. And one of them was that, well, she had so many children, she didn't know what to do. It's like she had so many acres, she didn't know what to do. Well, I happen to have 3 children, and I happen to be an expert on Mother Goose rhymes. And that is the old woman that lived in the shoe. That is not old Mother Hubbard. Old Mother Hubbard went to the cupboard to get her poor dog a bone. But when she got there, the cupboard was bare, and so the poor dog had none. What does that have to do with the oil and gas lease? So this baffled me for years. And when it came time for me to prepare this presentation, I thought, I'm going to answer this question once and for all. So I researched and researched and researched, and I couldn't find anything on the internet about Mother Hubbard other than this old nursery rhyme. But I happened to be reading the memoirs of John F. Kennedy. And in that memoir, he referred to someone wearing a Mother Hubbard dress. A Mother Hubbard dress. Now, that is the first time I'd ever heard of a Mother Hubbard dress. And so I went to look it up, and it is a dress that was in the Victorian era. Remember, that was about the time the original well was drilled. That was designed to address the issue of modesty. And so it covered a woman from her neck to her wrists, all the way down to her ankles. It covered all of a woman. And that's why it's called the coverall clause or the Mother Hubbard clause. It's named after this dress. Now, you're not going to find this anywhere in Wikipedia. This is just based on my research. And I would tell you this is the Mother Hogue theory of the Mother Hubbard clause. But doesn't that make sense that it would be the dress rather than the nursery rhyme? I also teach a class on what the Beverly Hillbillies teach us about oil and gas law. And one of them is that Granny, Irene Ryan, who played Granny, actually wore a Mother Hubbard dress. It covered her neck to her wrist, all the way down to her feet. And Granny takes it one step further, and she even puts the hat on. So that is my theory of why it's called the Mother Hubbard clause. The next clause also has an unusual name. It is called the Habendum clause. Now, Habendum, the word Habendum comes from the Latin to have, to have. So in weddings, they used to say Habendum and tenendum, to have and to hold. So when we're talking about this and so that would have been back there in the 1850s. This was probably a common thing that was said in weddings at the time. And so what it's basically saying is, how long are you going to have that oil and gas lease? How long are you going to hold that lease? Or refer to it as the term clause because it sets the duration of the lessee's interest. And it reads, subject to the other provisions herein contained, this lease shall be for a term of, and now this can be negotiated. So I've seen 6 years, I've seen 3 years, I've seen 5 years, and I've seen all the way up to 20 years. So whatever they put in here, that is the term. That means after that happens, the lease will expire unless there is production. So this, whatever this number is, that's referred to as a primary term. And then it goes on to say, and as long thereafter as oil, gas, or other minerals are produced from said land or land with which said land is pooled hereunder. So here you have a primary term, and then this is the secondary term. The secondary term kicks in once there's actual production. So primary term, secondary term. Let's look at them one more time. The primary term is the number that's in this blank. It basically tells you the exploration period. How many years do you have to explore and develop and try to find oil and gas before the lease expires? Secondary term is conditioned on there being actual production. So even if this says a 3-year term, if there's production, the production will keep that lease in force until the well stops producing. It could be 20 years, 30 years, 100 years. So that is the difference between the primary term, the initial exploration, and the secondary term, conditioned on there being actual production. Now, one thing the courts have defined is what is production. And they said that an oil and gas lease can only be kept in force if they have what's called production in paying quantities. Production in paying quantities. And what that means is that you have to be making more than break even. You have to be making on a profit on it. So the oil and gas lease is not going to be held if there's just someone or a well that's just dripping from the well. It's got to be enough production so that the oil and gas company can earn an interest. Now, there's exceptions to this, and one of them is the Pew Clause, as well as the pooling clause. So we'll talk about pooling, as I said, later, but pooling, even though you may not have actually production on your lease, if you are in a pooled unit and there's production, that would be enough to keep your lease in force. But we'll go into more detail about that in a minute, so don't worry if you didn't catch on to that part. Next is the royalty clause. Now, this is the major inducement for a landowner to enter into an oil and gas lease, and it's a cost-free share of production. Now, it's called a royalty clause because back in the Middle Ages, if you wanted to mine the royal gold mine or the royal silver mine, remember the monarchy owned not only the land but all the minerals, you had to pay a sum of money to the king. And that sum of money became known as a royalty payment because you were making the payment to the royalty, to the monarch. And we still use that term today. Now, the royalty clause is measured as a percentage of proceeds. So you'll hear a 1/8 percent or a 12.5%, or a 3/16 or a 1/4 or a 1/5. So these are the typical percentage of production. So as an example, if you have an oil and gas lease that is with a 3/16 royalty, and that well produces $500,000 that month, you will get a check in the mail for $93,750. That's called money for nothing, is what Dire Straits would call that, or it's also known as mailbox money. Passive income. You don't have to do anything but wait for the check to arrive. Now, the language of this says that the royalties to be paid on by lessee are on oil 1/8, and remember this is negotiated, 1/8 of that produced and saved from said land, the same to be delivered at the well. And then it goes on for gas, and it says on gas, including all blah, 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 usually casing head gas, 1/8 of the amount realized. Now, when I was analyzing oil and gas leases for Exxon, we did not even notice this clause. We would take what the fraction was, but we really didn't even understand what all this other language is. Well, today it's very important that you understand what this language is because the hottest litigation going in the oil and gas industry today is on post-production costs. Now, this applies to gas, and what happens is that after there is production, and it's a gas well, there are certain items that can be deducted. Or there are certain items that, let me rephrase that, there are certain items that, certain processes that gas has to go through to be marketable. And some of these are, one, it has to be separated. So we have to separate the oil from the gas. And then it's got to be dehydrated. We've got to get the water out of it. And then it's got to be compressed. This is a machine or an engine that forces the gas through the pipeline. If we didn't have compression, then the gas would just sit in there. And then we have transportation. So these are the things that they're looking for. There's one more, and I'm not remembering it right now. Compression, dehydration, separation. Not coming to me. So the thing is, does the oil and gas company have the right to deduct these costs from the royalty owner's royalty payment? And so different states have different laws, and that's why it's so important that you need to understand the laws of the geographic area where you are working. So for example, in Texas, if this had said gross proceeds, and the oil and gas company deducted these costs from the royalty owner, then the oil and gas company would be in breach of contract. Now, if it said net proceeds in Texas, net proceeds says that we can deduct this. Payments are based on the net amount. So what's happening in litigation right now is there's a number of class action lawsuits where they find these old leases from the 1920s, from the 1930s, or even more recent leases, and they look at them and they realize all this time the oil and gas company has been deducting these costs from the royalty share. Now, here's one way to think about that. The royalty owner's share is 3/16. What is the oil and gas company's share? Theirs is 13/16. Okay, 3/16 equal a 0.1875 or 18.75%, and 13/16 equal 0.825. So we have one party with 82% and we have one party with 18%. Who is going to pay for these costs to make the gas marketable? And the oil and gas companies have been taking it all out of the person that's only getting 20%. Now that's fine if that's what the contract says. But the contract in a lot of cases, another example is Oklahoma, and Virginia is like this as well. In Oklahoma and Virginia, it's got to spell out that the oil and gas company has the right to deduct separation, dehydration, compression, transportation, all those costs they have the right to deduct. If that lease says anything else, gross proceeds, net proceeds, amount realized, market value, without specifying that they have the right, in that case, if the oil and gas company deducts those costs, they are in breach of contract. So now we really pay attention to this royalty clause. Very important that you know what the language is and make sure that your company abides by that by making sure those costs are not deducted. Okay, so royalty clause is one of the major inducements. Another, really to a lesser extent, is the drilling or delay rental clause. Now, this is also known as the unless clause. It's known as the unless clause because what it's basically saying is, look, you're either going to drill a well or you're going to pay delay rentals or the lease is going to terminate. Those are your options, buddy. So it's called unless. The lease is going to terminate unless you either 1, drill, or 2, pay delay rentals. Now, this clause reads, if operations for drilling are not commenced on said land or on acreage pooled therewith as above provided on or before 1 year from this date. So this is 1 year from the date that's set in the granting clause, or sometimes at the end of the lease they have an effective date. It's 1 year from that effective date. The lease shall then terminate as to both parties unless on or before such anniversary date, the lessee shall pay or tender, or shall make a bona fide attempt to pay or tender, as hereinafter stated, to lessor or to the credit of lessor, in this bank, at this location, the sum of so much money, which shall cover the privilege of deferring commencement of drilling operations for 12 months. So this is a payment that needs to be made once a year on the anniversary date of the lease if there is no production. So you better either drill or pay that delay rental. So even though the lease term may be 3 years, if it's a delay rental lease, if you don't make that payment after the first year, the lease expires. So that's kind of a tricky part of that. Now, this is a very severe consequence. So you either drill or pay delay rentals or you lose the whole lease. In fact, if you are 1 penny off in your calculation of this delay rental payment, that lease is going to expire. If you're a ½ acre off in your calculations, that lease is going to expire. So in other words, that lease has to be in the proper amount. It's got to be on or before the due date. It's got to be to the proper person, and it's got to be in the proper manner. Now, the failure of any of these results in automatic lease termination. So what do companies do to avoid this extreme consequence? Is they use a type of oil and gas lease that's called a paid-up lease. Now, in a paid-up lease, what we're basically saying is, here's your bonus payment, and this covers not only the bonus, but it also covers your delay rental for all the years that this lease is, the term of this lease. So that's called a paid up lease. That's what we want to use because then we don't have to worry about this dire consequence. But there are plenty of delay rental leases out there. And so your company is going to be responsible for making those payments on or before the due date. And that is before midnight of the date of the lease anniversary. So if we had today, April 15th, Wednesday, April, but if it's April 15th, for example, 2015, that lease is going to expire April 15th, 2016 at midnight. So you got to pay it before that amount, before that time. Now, what a lot of companies will do is they will pay it way in advance. So they'll pay months in advance just because they don't want to run into this severe consequence. So that's the royalty clause and the drilling and delay rental clause. Now there's another kind of royalty clause that is a little bit tricky because it only kicks in if it's a gas well. If it's a gas well, in order to transport that gas, we have to put it into a pipeline. Oil, we can just put in trucks and truck it away. But for gas, if we just put it in a truck, it'll dissipate into the air. So we have to put it into a pipeline, and it takes a while for that pipeline to be built. So if there is production, if the well is capable of production, but it's not producing because we're building a well or because we're negotiating the contract with a purchaser, in those two cases, that would trigger this shut-in royalty clause. Now, there's a difference between a mechanical shut-in of a well and a legal shut-in of a well. So you may have an engineer that calls you and says, well, we shut the well in. Let's go ahead and start making those shut-in royalty payments. And your answer will be, well, why did we shut the well in? And he'll say, well, something fell down the hole and we've got to fish it out. And you say, you do your job and I'll do my job. Because this kind of mechanical shut-in is not what triggers the shut-in royalty clause. The only thing that it triggers is if we're waiting for the pipeline or if we're waiting for a gas contract. Now, what's tricky about this is when to pay this thing. It's not tricky. It's not very expensive. Like here, it's 1/12 of $1 per acre for the acreage, but it's got a really complicated formula. So it's basically saying if there's a period of time, let's go back to our April 15th, 2015. If there's a period of time between April 15th and April 16th, that is over 3 months. So for 3 solid months, there is no production. Then this month, April 2016, you have to make a shut-in royalty payment to keep that lease in force. So let's read it together. While there is a gas well on said land or on lands pooled therewith, and if gas is not being sold or used for a period in excess of 3 full consecutive calendar months, and this lease is not then being maintained in force and effect under the other provisions hereof, lessee, that is the oil and gas company, shall tender or pay to the lessor, the landowner, annually at any time during the lease anniversary month of each year immediately succeeding any lease year in which a shut-in period occurred, 1/12 of the sum of $1 per acre for the acreage then covered by this lease as a shut-in royalty for each full calendar month in the preceding lease year that this lease was continued in force solely and exclusively by reasons of the provision of this paragraph. If such payment of shut-in royalty is so made, it shall be considered that this lease is producing gas in paying quantities. So that's the shut-in royalty clause. Now, in a lot of oil and gas companies, there is one person in the lease administration group that handles shut-in royalty clauses only. And there's also shut-in royalty attorney provisions where you hire an attorney to say when this needs to be paid. So this can be pretty tricky. But shut-in royalty clause. Now, the production again has to be, it's got to be in paying quantities, at least. In other words, it's not just a little bit of gas coming out. It's enough so that there is a profit. Now, the next 3 slides we're going to cover are what we call the savings clause. And the reason it's called the savings clause is because it prevents the lease from expiring. Okay, it saves the lease. So the first 2 occur during the primary term, and the last one occurs after the primary term. And this is the one that you're going to quote to your engineer, the one that's after the primary term. So let's say that you drill a well and there is no oil in that well. What do? Well, we have 2 options. We can either drill a second well, or we can start paying delay rentals again. So the goal here, the mutual interest of both the lessor and the lessee, is for there to be oil coming out of the ground, oil or gas coming out of the ground. So the lessor isn't going to say, oh, well, you drilled a dry hole, game over. They're going to say, that's okay, oil and gas company. You can go ahead and try to drill a second well, or if you want, you just start paying us rentals again. Because remember, the lessor is going to get a lot of money if there's production coming out of this well. So the dry hole clause itself reads, should any well drilled on said land during the primary term before production, so this is during the primary term and before production is obtained via dry hole, or should production be obtained during the primary term and then it stops, then and in either event, if operations for drilling an additional well are not commenced or operations for reworking an old well are not pursued on said land on or before the first rental date, next exceeding the expiration of 60 days. Now, this can be 60 days, this can be 90 days, this can be 180 days, but what it's saying is basically, if there is a dry hole, we're going to give you 60 more days to either drill a second well or resume rentals. So 60 days after the cessation of production or drilling or reworking operations on said well or wells, then this lease shall terminate unless on or before said date shall resume the payment of rentals. So that's the dry hole provision. It is a savings clause during the primary term. The next savings clause during the primary term is the continuous drilling clause. Now, the way this clause works, remember, it's during the primary term. And what it basically says is that if we give an oil and gas company a lease that's dated April 15th, 2015, and the oil and gas company starts drilling back in December, and this lease is going to expire April 15, 2016. Say it's a 1-year term. So they're drilling and they're drilling and they're drilling and they're having all kind of problems drilling. And so they drill past January, they drill past February, they drill past March, and it looks like they're coming right up on that date of April 15th. So does that lease then just terminate at that point while they're still drilling? Well, the answer is no, because again, the lessor wants that oil and gas company to be successful so they can get their money for nothing, their mailbox money. And so basically what this clause says is, okay, oil and gas company, let's say that this lease expires on this date and you start drilling, and before you're done drilling, you pass the expiration date. We're going to let you continue to drill. And if it's successful, if there is a successful well, what am I trying to draw here? If there's a successful well, we'll just treat it as if it was drilled during the primary term. So it's during the primary term. It prevents the lease from expiring while they're drilling. And let's just read it together. If lessee shall commence to drill a well or commence reworking operations on an existing well within the primary term of this lease, remember, we're still in the primary term, or any extension thereof, or on acreage pooled therewith, the lessee shall have the right to drill such well to completion or complete reworking operations with reasonable diligence and dispatch. And if oil or gas or either of them be found in paying quantities, this lease shall continue and be enforced with like effect as if such well had been completed within the term of years first mentioned. So that is the continuous drilling clause. Now, because it goes past the primary term, rental payments are not going to keep this lease in force. But if it's a successful well, then it'll be as if retroactively it did occur during the primary term. All right, the next one is the cessation of production. Now, this is what you use to tell your engineer. The engineer calls, this is past the primary term, way after the primary term, or it could be, not way after, I'm being dramatic, but past the primary term. The engineer calls you and say, hey, we've got something in the hole, we got to fish it out. Go ahead and start paying shut-in royalty payments. You say, you do your job and I'll do my job. But what you really need to tell that engineer is, okay, you've stopped production for whatever reason, and it's past the primary term. You have 60 days to get that well back online, or we lose the lease. So it reads, if after the expiration of the primary term, again, this is past the primary term, production on this lease shall cease, this lease nevertheless shall continue in force if drilling and reworking operations are commenced within 60 days. Now, this can be 60, 90, 180, after such cessation of production. If production is restored, or if additional production is discovered as a result of any such drilling or reworking operations conducted without cessation of more than 60 days, this lease shall continue as long thereafter as oil or gas is produced and as long as additional drilling or reworking operations are had without cessation of such drilling or reworking operations for more than 60 days. So you're telling your engineer you have 60 days to either get that well back online or find an additional discovery. So those are the three savings clauses, 2 during the primary term, 1 after the primary term. The next clause we're going to look at is the pooling and unitization clause. Now, we're going to go over this in more detail in week 3, but just to give you a high-level approach, every state has laws that says you can only have one well for so many acres. They're trying to avoid a situation like they had in early oil and gas, where let's say in this puzzle here that each puzzle piece represents a separate landowner, where everybody had a single well on their land. You've seen those pictures of early oil and gas fields. Well, pooling basically says the state says you can only have one well on so many acres. So if that is the case, everything that's in that pooled unit is going to share in that production, even if the well wasn't drilled on their property. That's what pooling is. It's combining small or irregular tracts into a unit that's big enough to meet state spacing regulations. Now, there is a little bit of confusion because there is something called, this is called a pooled unit, and then this is called unitization. Unitization occurs when we're at the end of the life of the well, and the state says you can only have one well, but we've got to put in another kind of well, like an injection well, and then we can then combine a bunch of these pooled units together and say there's one reservoir under all of this, so these are all unitized. Don't get hung up on it now. We'll cover it in more detail in week 3. But it says lessee at its option is hereby given the right and power to pool, unitize, or combine the acreage covered by this lease or any portion thereof as to oil and gas or either of them with any other lands covered by this lease and or with any other land, lease, or leases in the immediate vicinity thereof to the extent hereinafter stipulated. So that is your pooling and unitization clause. All right, hang in there, guys. We're getting there. The next one is the surrender clause, and it basically gives the lessee, the right to terminate this agreement at any time. Does the lessor have the right to terminate this agreement at any time? No, it's only the lessee. The lessee alone has the right at any time without lessor's consent to surrender all or any portion of the leased premises and be relieved of all obligations as to the acreage surrendered. Now, this gives them the right to terminate at any time. Ideally, when they terminate a lease, we would love to see a release of lease of record, but that doesn't always happen. But in an ideal world, there should be a release filed of record. Okay, the next clause seems obvious, but it's got a little catch to it. It's called the force majeure clause. And basically what it says, it's a major force or an act of God. And this says that anything that happens, usually we think of a natural disaster, that prevents the oil and gas company from meeting its obligations, then in that case, the lease does not expire. So in 2006, Hurricane Katrina hit New Orleans, Louisiana, and there was an oil and gas company called Dominion Exploration and Production. All of their employees evacuated. So those delay rental payments didn't get made that month. Did all those leases expire? And the answer is no, because of the force majeure provision. It prevents the lease from terminating for causes that's be out of the control of the lessee. Now, what we can do as oil and gas company is make this broader. So it's not just a natural disaster, but we can say if there's some kind of governmental action or some state or federal law, or maybe we haven't had time to get a well permit, that is a force majeure. So here in this case, when drilling or reworking production or other operations are delayed or interrupted by force majeure, that is by storm, flood, or other acts of God, fire, war, rebellion. Okay, everybody's on the same page here. Insurrection, riot, strikes, well, maybe not strikes, or as a result of some law, order, rule, regulation, requisition, or necessity of the government, like a well permit, this lease shall not be terminated, nor lessee held liable in damages if compliance with covenants in this lease is prevented or hindered by any act of God or of the public enemy. So they've taken this natural disaster, what we usually think of a force majeure, and they broadened it. And they said, by the way, if we can't get a well permit in time, under the provisions of this force majeure, that is considered something that's out of the control of the lessee. So we want it written really broadly. The lessor probably wants it limited to just literal acts of God. So that is the force majeure clause. The next is the assignment clause. It allows either party to assign the rights. So the lessor can transfer his rights to somebody else. The oil and gas company can assign his rights to someone else. It also says there can be no increase in the lease obligations. And this is the clause that we use when we're doing changes of ownership. And it says the rights of either party may be assigned in whole or in part, and the provisions hereof shall extend to their heirs, successors, and assigned, but no change or division in ownership of the land, rentals, or royalties, however accomplished, shall operate to enlarge the obligations or diminish the rights of lessee, and no change, this is the critical language, and no change or division in such ownership shall be binding on lessee until 30 days after we've been furnished with a certified copy of a recorded instrument evidencing the change. Now, this is important because it puts the burden on the lessor to notify us if there's been some kind of a transfer. So we don't want the situation where somebody comes along and says, hey, you've been paying my uncle for the past 3 years and I actually owned it, so I'm going to sue you for wrongful payment. We'll basically use this provision to say we didn't know that. It's your job to notify us because we can't possibly look in the county records of every county in every state where we own property. So this clause puts the onus on the lessor. The next clause is the warranty clause. Now we use this clause if we want to avoid the property from going into foreclosure. So it basically says to us, okay, if someone's about to foreclose on your property, either because of a mortgage or a lien or whatever, you give us permission to pay that mortgage or that lien on your behalf. And then we'll just deduct what we paid out of your royalty payments. What that does is it protects the oil and gas company from having the property go to a sheriff's sale, and then you've got all kind of bureaucratic red tape. Just give us permission to do it. And the other thing it does is it gives us the recovery from title failure. Now, I usually see this struck, this provision, but a lot of my students told me they don't really see it struck that often. But this part here, it says the lessor hereby warrants and agrees to defend the title of said land. And okay, so they'll just delete this part. The lessor hereby warrants and agrees to defend the title to said land. So what the lessor is saying is, look, we're not going to guarantee that we are the owner of this property. We think we are, but you're the one that ran the chain of title. You're the one that hired an attorney to draft an opinion about the ownership. So if there's a problem with the actual ownership of the title, you can't come back and sue us. So they'll usually delete this warranty clause. The next clause is the legal effects and signatures. It says that the lease is effective when it's signed. It's binding regardless of who else signs. So if you own a 50% interest in a property and you sign the oil and gas lease and the other 50% owner does not sign, you are still legally bound. Now, this part on cloud on title, I just wanted to point out that as a landman, you want to make sure that they sign their name exactly as it is in the granting clause of the lease, because the granting clause is based on the county records. The name that's on the last deed or the last conveyance instrument then becomes the name on the oil and gas lease. Now, you may recall if you've ever purchased a home at closing, the closing agent will say, okay, please sign your name exactly like this every single time. That's to avoid a cloud on title. And the same thing happens in the lease. We want them to write their name exactly the way it is in the granting clause. Now, this says all of the provisions of this lease shall inure to the benefit of and be binding upon the parties hereto, their heirs, administrators, successors, and assigns. This agreement shall be binding on each of the above named parties who sign the same, regardless of whether it is signed by anyone else. And this instrument is executed on the date first above written. So here it could say a new effective date. The effective date of this instrument is blank, but it's usually what's in the granting clause. And then you're going to make sure that the landowner signs their name exactly as it appears in the county records. So we have gone through every provision in that oil and gas lease. Let's look at what we covered today. We began with an introduction where we talked about the definition of an oil and gas lease. We talked about the distinction between the lessor and the lessee. Then we looked at the mutual benefits for the lessor and the lessee, and they're both motivated by money. The oil and gas company obtains substantial profits from drilling and development, and the landowner likewise, or the lessor likewise, incurs significant payments based on the royalty payments. We talked about the different lease forms, and I said there's a Producers 88 lease. You don't even need to read that lease. All the provisions are exactly the same, right? Wrong. These lease forms, the numbers at the top of them, really mean nothing. You need to read word for word, line by line, every part of this lease, just like Boudreaux had to read that telegram. And then we looked at, I gave you a little bit of history of why it's called the Mother Hubbard Clause, because in 1859 it was the Victorian era, and we said that the oil and gas leases were based on the saltwater extraction leases. And then we went through each lease provision. You have a lease analysis cheat sheet. Oops. And that concludes our presentation for today. I hope you have enjoyed this webinar, and I look forward to seeing you in the next one.